Hello, dear friends. Welcome you all in this learning platform of P. Sharman Shukla Study Group. Today, I will discuss some news articles in the Hindu newspaper. First one is narco ruling on narco test. The Supreme Court has set aside the narco test ruling of Patna High Court. Patna High Court ruling on narco has been set aside by Supreme Court. What are the logic Supreme Court has given? Supreme Court has said that this ruling of Patna High Court is unconstitutional. Why this is unconstitutional? Because it is involuntary and forceful and without consent. This is the reasoning has been given by Supreme Court, and Supreme Court has said the guidelines related to narco test, the guidelines which has been given by Supreme Court in Selvi versus State of Kerala, not Kerala, State of Karnataka. Then, in this judgment, Supreme Court has given some guidelines while performing this narco test. What was the guidelines? The guidelines was the consent of the accused is mandatory. Consent of the accused is mandatory, and these consent should be in front of magistrate concern. The consent should be taken from the accused in front of concerned magistrate, and medical, legal, and procedural medical, legal, and procedural safeguard should always be there for accused. What was the constitutional validity of this narco test? Article 20. Article 20 is class 1, class 2, and class 3. There are three clause in this article. And this article is the foundation of criminal justice system. What is written in these three clauses? First one, 21, no ex post facto law. That means if Parliament passes any law, then that law will apply from the date it passes and afterwards, not in the past. Whatever crime has been committed in the past, this law or this act would not apply to those crimes. This is the ex post facto law. Second one is clause 2, 20 clause 2. No double jeopardy. That means any accused will not be punished twice for the same offense. And the third one, that is Article 20 clause 3. No self incrimination. No person would be forced to become witness against himself. This is Article 20 clause 3. And on the very basis of this article, this clause, this narco test analysis and narco test has been declared unconstitutional because that was without consent. The rights of victim and accused should be balanced. Here, the concept of golden triangle, that means Article 14, Article 19, and Article 21 would also come in the picture. Next article is criminals forcibly administering acid deserves higher punishment. Harsher punishment. CJI hearing a case. Acid ingestion. That means the accused has given acid to ingest the victim, and the PIL was and the appeal was filed by victim. What was the statement CJI has given? That the punishment for the accused, punishment in this case is lesser, and there should be harsher punishment. They are appealing state government to frame law and increase the stricter and harsher punishment of this whenever any accused administers acid to the victims, because these accused are the dangerous animal to the certain dangerous person, a dangerous any element to the society, and they deserve higher punishment. And further, they said whatever punishment is under UAPA is provided, the accused under this case of acid administered acid attack would be given more than that. What is the next article? DPIIT signals Copyright Act changes to address AI issues. What this DPIIT said? They have given their proposal that the copyright also to be the AI generated content, because what these firms who is developing AI, who has developed AI, they are using LLM, that is large language model, and they are picking up the content from internet, and they are charging from customer in the form of subscription fee. Then why should not these AI firms be charged some royalty? These the proposal has been provided by DPIT. What is the next article? What went wrong? 1 minute. Supreme Court says migration in the SIR order may include illegal crossing into India. The Election Commission has given their definition, not basically definition, has said the migration is from rural to urban India. But the Supreme Court said Indian cities are much urbanized and they are sensing the possibility of migration from other countries to India also. Aadhaar app to enable offline sharing by exposing minimal data. This is only proposal when this article and this app will come, then that will be discussed because this app is under developing state. Madras High Court judgments. This is a good article. Not Madras High Court judgment, but this is the article related to Madras High Court. Actually, Madras High Court has given their proposal. Six High Court judges. Appointment of six High Court judges. Six district court judges. To the High Court bench. The Collegium has given their recommendation to state government, but the state government has not raised objection about the merit of the this six High Court judges, six district court judges to be repeated to Supreme Court. But they has this High Court, this state government has raised their concern or sought the clarification about the constitution of collegium. Why this constitution of collegium is under question, I will discuss. Just there was a lawyer. What was the name? Nisa Hanu. J. Nisa Bhanu. She was the head of Women Lawyer Association of Madras, Madras High Court, Madurai Bench, Madurai Bench. She was elevated to High Court judge and she was third in seniority list and second most senior judge. Earlier Supreme Court has directed the law ministry and this law ministry has issued circular to transfer him circular issued notice to transfer Judge Nisa Bhanu from Madras to Kerala, but refused to go there and admittedly is a collegium member. In Kerala, he would become ninth senior most judge, but in India, in Madras High Court, he is third senior most judge and the member of collegium system. Why state government has sought clarification about the constitution of collegium? Because under Article 217, appointment of High Court judges is there. What is the procedure? The collegium system. The collegium C J plus two senior most judges. But what this Madras High Court has done The senior most judges, that means Her Lordship, has been replaced by another judge which is next to senior, and what the name of that judge is Mr. Ramesh or something. Her Lordship has been replaced in the collegium by Mr. Ramesh, who is the next judge or senior most judge in the collegium, and this state government is asking for clarification why this senior most judge has been ignored, and this is logical also. The state is entitled to get the clarification why this senior most judge has been ignored and has been avoided. This is the story of this article. Collegium system, we discuss about collegium system. Collegium system is always in criticism. Why this is always in criticism? Because of its opaqueness, lacks transparency, accountability, nepotism. What went wrong? Nepotism and political influence also. Some lawyers or some legal fraternity also criticizing of this collegium system because of not being part of this bench. A large section of is not represented. That's why this collegium system is also under criticism. What is this collegium system? Collegium system has been the concept of this collegium system has been given the second judge's case, second and third judge's case. That's all about this article. What is the next one? Madras High Court. Next one is playing to gallery. What is it? This is a Karnataka's bill. What was the name of this bill? Hate speech and hate crimes. Hate crimes prevention bill. 2025, the Karnataka government has come with a bill of hate speech and hate crime. This will always be in question of the applicability of this act because there is always a slippery side, slippery slope, because the definition or the criteria under the hate speech is always a politically dominated matter. Religion, race, caste, sexual orientation. What is the criteria on which basis religion, race, caste, sexual orientation? This is the basis on which this hate speech is given, and the state government has tried to define the terminology, I think, which is undefinable, indefinable. What is ill hatred, ill will, ill will, harmony, enmity, enmity. This type of terminology the state government tried to define, but this is indefinable. If we talk about in the reference of hate speech, why? Because the political parties in power will always take the benefit of this bill. They always define the criteria in accordance with their political ideologies, and they will position. They said they are correct, but the opposition is wrong. Opposition is wrong if the opposition party is trying to give hate speech in the same manner on the same context they are making. And another thing, whatever the food This bill is trying to make to the society, it is much lesser than the harm it will do to the society. That's why the writer has said that the state has to play with the fire. State has to play with the fire while implementing the laws. This is the article. This is the main intention of the authors. Thank you.